I make a very clear and simple motion to move into executive session so that Senator Blumenthal's motion may be considered.
The motion is out of order.
Well, they're not out of order, Mr. Chairman. They're properly before this committee. Simply saying so, with all due respect, and I have great respect for the chairman, doesn't make them so. It doesn't make them out of order just because the chairman rules that they're out of order. We have a number of excellent lawyers in this room, and I ask that this body now do what its responsibility is, to have an executive session so we can vote on a motion to adjourn, and then we can deliberately and thoughtfully consider the documents that have been presented, and also review the committee documents that have been marked confidential without any reason or rationale.
The motion is denied.
Sir, how long would that take? 10 minutes for us to have a motion and a vote on this process? I don't understand what the rush is that we can't even let senators vote on what is a very important motion germane to our constitutional duties before this body, before we proceed. I don't understand. It won't take that much time. What is the rush? What are we afraid of to hold a vote on the motions before us?
Mr. Chairman.
Senator Kennedy.
Thank you, Mr. Chairman. I have a question about the process. I understand my colleague's point, and I understand they feel strongly about this. But what are going to be the ground rules today? Are we going to be allowed to interrupt each other? Interrupt a witness? Are we going to, should we seek recognition from the chair? I just want to understand the ground rules.
Proper respect and decorum, plus how we normally have done business in a hearing like this. We wouldn't be having all these motions. You're new to the Senate, so this is something I've never gone through before in 15 Supreme Court nominations that I have been since I've been on here. And every member, I was interrupted before I got a chance to say what the agenda for today, but every member is going to get 10 minutes to make their remarks, and then we will go to the introducers of Judge Kavanaugh. There will be 3 of those. They will take the usual time of introducers, and then we will have the swearing in of Judge Kavanaugh, and then we will have his opening remarks, and then we will adjourn for today. We'll reconvene at 9:30 on Wednesday and Thursday. Each member will have 30 minutes to ask questions or make all these points they're making right now for the first round. Then there will be a second round of 20 minutes each. So every member is going to get 50 minutes to ask all the questions or make all the statements that they want to make in regard to anything about this candidate or anything about how this meeting's being conducted. And then we will go late into Wednesday night or Thursday night till we get done with the questioning of Judge Kavanaugh. And then on Thursday, we're going to have 3 panels of 6 each, evenly divided for people that think Judge Kavanaugh should be on the Supreme Court and people that think he should not be on the Supreme Court. And we hopefully get that done Friday, but if we have to go Saturday and Sunday, we'll go Saturday and Sunday until we get it all done.
Mr. Chairman, how can we possibly...
Does that answer your question, Senator Kennedy?
Well, if I want to... Yes, Mr. Chairman, I appreciate it. If I want to say something, do I need to be recognized by the chair?
That would be the way that it's handled. I've tried to explain to you, I'm going to be patient, because sometimes if you aren't patient and you argue why something shouldn't be done, it takes longer than it does just to listen to people. But I don't think we should have to listen to the same thing 3 or 4 times.
Well, patience is good, Mr. Chairman. But I just want to understand the rules. If I want to be recognized...
you should be recognized. You can understand that I have been patient and listened to people not be recognized and speak anyway, because I would like to have this be a peaceful session.
Before I try your patience, I'm done.
Mr. Chairman, I have a question about ground rules.
Go ahead.
The question is, before we can proceed, I'd like to know whether the majority is still requiring of all of the Democratic members of this committee to pre-clear the questions documents and videos that we would like to use at this hearing.
I was hoping that on the subject that you just brought up, that we would have some clarification of what you want to approach that. And I'm not prepared to answer that question because I don't know what the answer has been, and I don't want you to give me what you think the answer has been of discussion between our staff on that subject.
Mr. Chairman, I don't think it's ever been the case in a hearing like this that the members of this committee have to pre-clear what we propose to query the nominee about. I think that is totally unprecedented.
And Mr. Chairman, if we don't even know what the rules are, how can
I'd
we
like to
proceed with
respond.
this?
I'd like to respond to Senator Hirano. The reason why we're having that discussion is, at least in my time on this committee, and for 15 nominations, we've never had a request for a video. So it seems to me, to be courteous to all the members of the committee, it'd be nice to know the purpose and what it might contain. Any questions you want to ask, you can ask questions. It isn't about what questions you were going to ask. It's about the presentation of something that's never been a part of a Supreme Court hearing in the past.
Mr. Chairman.
Who wanted?
Mr. Chairman. Yes,
I think I'll go back and forth. Senator, tell us.
Mr. Chairman, I'm confused because I heard earlier that this was a reaction to the document releases last night, but I'm reviewing a tweet from NBC that said Democrats plotted coordinated protest strategy over the holiday weekend. All agreed to disrupt and protest the hearing, sources tell me. And subsequent Dem leader Chuck Schumer led a phone call, and committee members are executing now. So I just want to be clear: none of the members on this committee participated in that phone call or that strategy before the documents were released yesterday. Is this? Are you suggesting that this allegation is false?
This is not related.
Senator Durbin.
Mr. Chairman, there was a phone conference yesterday, and I can tell you at the time of the phone conference, many issues were raised. One of the issues was the fact that over 100,000 documents related to Judge Kavanaugh have been characterized by the chairman of the committee as committee confidential. I've been a member of this committee for a number of years. Committee confidential documents have been really limited to extraordinary circumstances. As an example, if someone is accused of taking drugs during the course of an investigation, I'm not making any suggestion that that is even the case or close to it here, it was done in a confidential setting, in fairness to the nominee. And the same thing on DUIs and the like. We used it in extremely rare circumstances where we would meet after this committee hearing and sit down, and it usually related to a handful of pages or a handful of document references. Instead, what we found now is that we are seeing hundreds of thousands of documents characterized as committee confidential unilaterally. It's not done on a bipartisan basis. It's being done by the chairman. So one of the discussions yesterday was this whole question of whether this committee is going to hear a nominee for a lifetime appointment to the highest court in the land without access to basic information about his public record. His public record as Secretary to the President of the United States, Staff Secretary. 35 months of public service, we've been told, or cannot even be considered. The documents of that service cannot even be considered. So I'd say to the gentleman, or the senator from North Carolina, there was a conversation yesterday about these documents. I had no idea that at 11 o'clock last night, 42,000 more documents would be put on top of us, and we'd be asked to take them up today. So it added insult to injury.
Mr. Chairman,
Chairman, I ask to be recognized under Rule 4. Rule 4 states the chairman shall entertain a non-debatable motion to bring a matter before the committee to a vote. If there is objection to bring the matter to a vote without further debate, a roll call of the committee shall be taken, and debate shall be terminated if the motion to bring the matter to a vote without further debate passes with 11 votes in the affirmative, one of which must be cast by the minority. I ask for a vote on my motion to adjourn under Rule 4, Mr. Chairman. These are rules that we are obligated to follow. The chairman has no right, with all due respect, to simply override them by fiat.
Yeah. We are obligated. We are obligated by that rule in executive session. We're not in executive session. I would respond. I would respond to the issues brought up by Senator Durbin about confidential documents. I was criticized for my decision to receive some documents on committee confidential, but I'm doing exactly what I did during Justice Gorsuch's confirmation and what Chairman Leahy did during Justice Kagan's. This is another example of treating regular committee practices as somehow out of the ordinary. Presidential records that we receive often contain highly sensitive advice to the president, as well as personal privacy information like full names, date of birth, social security numbers, and bank account numbers. Like my predecessor, I agreed to receive some presidential records as committee confidential so that both Democrats and Republicans could begin reviewing Judge Kavanaugh's materials much earlier. I don't know why my Democrat colleagues object to receiving documents faster, but not all of these presidential records remain confidential. In fact, nearly 2/3 already became public. These records are posted on the committee's public website and available to the American people. As a result, we provided unprecedented public access to a record number of presidential records and did it in record time. The most sensitive presidential records remain committee confidential under federal law, just as they were during the nominations of Kagan or Gorsuch. But we have expanded access to these documents also. Instead of just providing access to committee members, we provided access to all 100 senators. Instead of just providing access to a very few committee aides, we provided access to all committee aides. And instead of just providing access to physical binders of paper, we provided 24/7 digital and searchable access. This is unprecedented access to committee confidential material. I'd also like to add that my staff set up workstations and have been available 24/7 to help senators who are not on committee access confidential materials, but not one senator showed up. I guess senators complaining about lack of access to confidential documents weren't really interested in seeing them in the first place. But I want to emphasize more documents are widely available than in any prior Supreme Court nomination. And then to the issue about hiding committee confidential documents. Some colleagues, and you've heard it this morning, accuse of hiding documents. They're suggesting that some of the committee confidential documents contain information that would be of great interest to the public. Well, just as I did last year during Justice Gorsuch's confirmation, I put a process in place that would allow my colleagues to obtain the public release of confidential documents for use during the hearing. All I asked was my colleagues to identify the documents they intended to use, and I would work to get the Department of Justice and former President Bush to agree to waive restrictions on the documents. Senator Feinstein secured the public release of 19 documents last year under this process, and Senator Klobuchar secured the release of 4 documents this year. If my colleagues truly believe that other committee confidential documents should have been made public, they never told me about them and requested the ones that they wanted. Instead of scaring the American people by suggesting that we're hiding some incriminating documents, they should have made a request that I work to get the committee confidential designation removed. This year, I received no such request except from Senator Klobuchar, which was honored and resulted in the disclosure of documents that she wanted to use during this hearing.
Mr. Chairman, you stated what I did, and you stated it inaccurately. I think I have the right.
I said I was paraphrasing.
Well,
You can correct me any way you want.
It was one heck of a paraphrase when you
Give me the
when you speak about doing the same thing as with Lena Kagan. I was chairman when Lena Kagan was here. we had 99%